still got some of them, their guns, they got it illegally, or some of them, they got it. Even the kid who got it, he wasn't on any kind of medication.
Why is the ATF trying to say a pistol's no longer a pistol? If you use a pistol brace, it's a short barrel rifle.
So far, we haven't heard back on if she's going to make a ruling regarding this delaying of permits.
The National Integrated Ballistic Information Network, NIBIN, allows us to connect disparate shootings through ballistic evidence.
A political battle where it should be a moral battle, in my opinion. We have the right to defend ourselves.
Update on the California handgun roster cases which recently were heard before the Ninth Circuit. Target on California gun laws. The rigorous restrictions on who is allowed to carry a concealed weapon in public in New York State were overturned by the U.S. Supreme Court in one of its most consequential gun legislation decisions in more than a decade. Advocates for stronger gun legislation condemn the 6-3 ruling, while gun rights supporters applaud it. Both concur that the next legal challenge may target a law similar to the one in California. Since the Supreme Court first made it clear in 2008 that all people, not just state militia members, had the right to keep and bear arms, the ruling is perhaps the most significant expansion of gun rights in the history of the U.S. That decision, however, only upheld the right to self-defense within the home, giving governments broad latitude in deciding whether and how to impose gun control in other places. With this decision, that constitutional right is extended outside the home. Justice Clarence Thomas argued for the majority of the court that restricting the right to bear arms to the house would be absurd. The decision was described by Governor Gavin Newsom as shameful and a dark day for America. The governor stated on Twitter that the judgment was dangerous and came from a court that was hell-bent on pushing a radical ideological agenda and infringing on the rights of states to protect our citizens from being gunned down in our streets, schools, and churches. In order to address the decision, Attorney General Rob Bonta stated that he will collaborate with the governor's office and lawmakers. In a tweet, Bonta stated more to come.
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
Gun violence is the greatest. In the case of the Parkland shooter,
because I hope we'll do more. Because the city of Indianapolis has higher murder rates than the city of Chicago.
Most states either grant concealed carry permits on demand or don't even require permits. However, in 8 states, those requesting permission to carry a concealed weapon around must first demonstrate a compelling reason. New York was one among the states up until the ruling. One more is California. Thomas remarked, describing both California's and New York's concealed carry laws, "We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. Where a Californian lives determines how simple it is for them to get a concealed handgun permit. This is so because county sheriffs or city police chiefs in California are the ones who grant these permits. Additionally, local law enforcement personnel have broad discretion to define good cause, even though state law requires applicants to show it. All qualified applicants are granted permits in counties with Republican sheriffs, such as Sacramento and Tehama, provided they pay the requisite fees, complete the state-mandated weapons safety course, and don't have a criminal record. The city of San Francisco is at the other extreme of the spectrum. County sheriff regulations provide that an applicant who resides in the city must supply convincing evidence that they are significantly at risk of danger, that local law enforcement cannot adequately address and cannot reasonably be avoided by alternative measures. Restrictive concealed carry laws like those in San Francisco are not immediately rendered illegal by the court's decision, but it does increase the likelihood of a successful legal defense of California's entire discretionary system. Democratic legislators in California are already drafting a bill in response. The new law will be attached to Senate Bill 918, which was already passed and was written by Glendale, California Democrat Anthony Portantino. The High Court's judgment leaves the door open for 2 potential solutions, he added, but the specifics are still being worked out. First, Thomas argued that if an applicant meets objective requirements, local licensing officials shouldn't have a lot of latitude to reject a concealed carry application. A background check and completion of a course on gun safety are requirements for this requirement in California. Nothing in the decision, however, forbids the state from imposing more limitations. Second, the judgment recognized that governments have the power to ban guns in sensitive places like schools or courthouses, but New York couldn't proclaim all of Manhattan a sensitive place. Portantino told Cal Matters, "What we're going to do with the bill is attack it from both of those perspectives." Rewriting the legal landscape. The decision, however, may have much wider repercussions that affect all aspects of California's gun regulations, including the state's ban on assault-style weapons and high-capacity mags, as well as its limitations on ghost guns. This is so because today's decision raises the bar for any limits on firearms. According to Thomas, the government may not simply posit that the regulation promotes an important interest in order to justify its regulation. Instead, the government must show that the legislation is in line with a long history of weapon regulation in this country. Chuck Michel, the president of the California Rifle and Pistol Association, the state's chapter of the National Rifle Association, told Cal Matters that he intended to file a number of new legal briefs in the ongoing court cases challenging the state's ban on assault weapons, background checks, large-capacity mags, and concealed carry restrictions in Los Angeles County. The state of California would now find it more difficult to defend its stringent regulations as legitimate, he claimed, adding that the decision is going to simplify the entire process of judging whether or not a gun law is constitutional. The Giffords Law Center to Prevent Gun Violence's state policy director, Ari Freilich, concurred that the decision might have wide-ranging effects. The consequences won't show up tomorrow or the next day, but the opinion is a fundamentally rewriting of the legal landscape and the battlefield on which all Second Amendment cases have been fought, he claimed. It undoubtedly jeopardizes a lot of what California and other states have battled for and protected over the years. Portantino presented the situation in a more optimistic light, particularly considering how soon after Buffalo and Uvalde the decision was made. He expressed his extreme outrage, disappointment, and sadness. But that only means we need to put in more effort, be more savvy, and be more conscientious. Congress is about to add a few minor additional safeguards at the same time that the top court in the country broadens the Second Amendment's application.
They gave him psychotropic drugs, and they put him back out on the street, and he killed people.
If the judge agrees to the postponement, then starting in February, anyone who purchases a gun in Oregon will be required to have a permit.
For gun purchases by 2 months, it is part of Measure 114, which voters passed in November.
The U.S. Senate enacted a bipartisan gun bill overnight over the objections of the National Weapon Association in response to the mass slaying in Uvalde, Texas, in which a slayer used a semi-auto weapon to end 19 students and 2 instructors. The House of Representatives approved the legislation, and President Joe Biden swiftly signed it on Saturday. The law would intensify some background checks for younger prospective gun purchasers. Additionally, it would offer cash to states interested in passing red flag laws, which make it simpler for law enforcement to take away a person's firearms temporarily if they pose a threat to themselves or others. Democrats in California's legislature are also debating a number of new gun laws. This includes legislation that exposes gun dealers and producers to a wide range of legal actions for selling weapons or ammunition to people who aren't entitled to possess them or for breaking state gun laws. I will have 16 new gun safety proposals on my desk next week, one of which will permit anyone to sue gun manufacturers and distributors for breaking specific gun laws. According to a news release, Newsom stated, "I look forward to signing all of those laws." Expanding concealed carry rights. The Supreme Court invalidated a New York statute that imposed severe limits on carrying a concealed pistol in public for self-defense, after determining that it was unconstitutional to require applicants for a concealed carry license to show a compelling need for self-defense. A lower court decision maintaining New York's 108-year-old rule restricting who can acquire a license to carry a concealed firearm in public was overturned by the Supreme Court in a 6-3 vote. Gun control laws in multiple states could be in jeopardy, and more weapons could end up on city streets, according to the measure's supporters, who warn that a high court decision to invalidate it could do so. The ideologically divided court's majority judgment was written by Justice Clarence Thomas, who argued that the licensing system in New York was unconstitutional because it prohibited law-abiding persons from enjoying their Second Amendment rights, and that the state's proper cause requirement did so. The constitutional right to keep and bear arms in a public place for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees, Thomas wrote. We are unaware of any other constitutional right that a person can only use after proving to officials that they have a specific need. When it comes to the free exercise of religion or controversial speech, the First Amendment does not operate in that way. When it comes to a defendant's right to cross-examine the witnesses against him, that is not how the Sixth Amendment operates. And that's not how the Second Amendment operates when it comes to carrying a weapon in public for self-defense.
Banning a class of weapons that you don't like the look of, not because of functionality.
Because law enforcement agencies simply just aren't ready for it yet. Measure 114 is set to take effect on Thursday.
How I am and my kids are going to be safer if I lock up my guns. I just feel, actually, as a female, I feel not as safe.
Justice Stephen Breyer, writing in dissent for the court's liberal majority, cited the growth in gun violence in the U.S. and the pervasiveness of firearms in his argument. He also cautioned that states attempting to enact stricter gun regulations will be severely hampered by the court's ruling. In my view, when courts interpret the Second Amendment, it is constitutionally proper, indeed often necessary, for them to consider the serious dangers and consequences of gun violence that lead states to regulate firearms, wrote Breyer. The Second Circuit concluded that New York's law does not violate the Second Amendment after making this determination. The court's ruling follows a spate of mass slayings from mid-May to early June that shocked the country and prompted Congress to once more look for agreement on a legislative strategy to reduce gun violence. 10 individuals were ended in a slaying spree on May 14 at a grocery store in Buffalo, New York, by a racist gunman. 10 days later, a slaying at an elementary school in Uvalde, Texas, resulted in the deaths of 19 students and 2 instructors. Then, on June 1, 4 people were shot and slayed outside a hospital in Tulsa, Oklahoma. Since the Supreme Court acknowledged in 2008 that the Second Amendment protects the right to keep firearms in one's house for self-defense, the verdict represents the first enlargement of gun rights. The New York legal dispute was also the greatest Second Amendment issue the court had seen since its 2008 verdict and a 2010 decision that stated that the states have the same rights as individuals to have handguns in the house. Supporters of gun rights hoped that the conservative Supreme Court majority of 6-3 would recognize that the Second Amendment safeguards the freedom to carry a firearm in public. Justice Brett Kavanaugh emphasized the court's ruling does not exclude states from enacting licensing requirements for carrying firearms and leaves unchanged existing systems in 43 states in a concurring opinion in which he was supported by Chief Justice John Roberts. Rather, it only affects stricter licensing laws that are in place in 6 states, including New York. In a statement, President Biden expressed his deep disappointment with the choice and once more pushed states to modify their laws to reduce gun violence. This decision should cause great concern for all of us, he continued, as it goes against both common sense and the Constitution. The 1913 New York permitting legislation at the center of the controversy calls for individuals who want to carry a pistol outside the home to show proper cause, which state courts have defined as a special need for self-protection. Robert Nash and Brandon Koch, the 2 plaintiffs in the case, both requested for a carry license, but licensing officials rejected their requests because they did not provide sufficient justification for carrying pistols in public. The 2 were given restricted licenses to carry weapons for hunting, target shooting, and other outdoor pursuits. Nash and Koch contested the validity of New York's ban on carrying handguns in public and the proper cause requirement in 2018. They were joined by the New York State Rifle and Pistol Association. Their lawsuit was dismissed by a federal district court, and the Second U.S. Circuit Court of Appeals upheld the ruling, maintaining the licensing system.
My executive manager is attempting to compel me to participate in an activity which placed public safety at risk.
It's mounted to the rear of the pistol. It's designed to anchor the pistol to the shooter's arm.
Photo ID, fingerprints, firearms training, a background check, and a permit issued by police to buy a gun.
Democratic New York Governor Kathy Hochul blasted the Supreme Court's decision on Twitter, calling it outrageous that at a moment of national reckoning on gun violence, the Supreme Court has recklessly struck down a New York law that limits those who can carry concealed weapons. The decision of the court, according to New York City Mayor Eric Adams, puts New Yorkers at further risk of gun violence. In order to ensure that only individuals who meet the requirements can acquire a license to carry, he promised to conduct a comprehensive review of the method used to determine the locations where carrying a handgun is prohibited. He declared, "We will do everything we can to dam it." This decision may have opened a new river feeding the sea of gun violence. On his Truth Social platform, former President Trump claimed responsibility for the court's decision, asserting that elections have consequences. I vow to name justices and judges who will uphold the Constitution. The Supreme Court upheld everyone's right to the Second Amendment today. A person may only carry a concealed firearm in public if they have a need to do so in about 6 other states, including California, Hawaii, Maryland, Massachusetts, New Jersey, and Rhode Island. Approximately half of the states require a permit from the state in order to do so. Even if the applicant satisfies the legislative requirements, government officials may choose to refuse permits in those 12 states. Officials from New York and the Biden administration, which urged the Supreme Court to uphold the law, cautioned the justices during oral arguments in November that overturning the rule could have a cascading effect, jeopardizing not only the state-level restrictions, but also other laws that restrict public carry in public places like airports, arenas, churches, and schools. Some of the judges were worried about the potential effects of a wide ruling on the limitations put on public gathering areas. Roberts, for instance, questioned whether a state or city could prohibit firearms in football stadiums or locations where alcoholic beverages are served, while Justice Amy Coney Barrett questioned whether it was possible to prohibit firearms in sensitive places, such as Times Square on New Year's Eve. Justice Samuel Alito criticized Breyer's dissent in his concurring opinion for listing recent mass slayings. Does the dissent believe that legislation like those in New York can stop or discourage such atrocities? Will someone intent on carrying out a mass slaying be stopped if they are aware that carrying a firearm outside the home is prohibited? And how can the dissent explain the fact that Buffalo was the site of one of the major slayings near the top of its list? It is clear that the relevant New York law in this case did not deter that offender. Legal challenge to California's handgun safety requirements. Bowling versus Bonta and Renna versus Bonta. Recently, a federal district court judge in California issued a preliminary injunction against the safety feature requirements set by the state's Unsafe Handgun Act. This injunction pertains to 2 cases, Bowling versus Bonta and Renna versus Bonta. These cases, involving the California Rifle and Pistol Association and Michel and Associates respectively, address the legality of certain handgun requirements in California. In California, a law exists that imposes specific criteria on handguns to be considered safe for sale to the general law-abiding public.
90% of the, mass shootings would have been prevented. Even if they do that, it would have been prevented.
You are issued weapons that allow for fully automatic and 3-round bursts. That is not available for purchase.
U.S. lawmakers passed the most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
These criteria include safety features such as a mag disconnect, a loaded chamber indicator, and micro-stamping technology. Handguns failing to meet these criteria are labeled as unsafe and cannot be sold to average citizens in the state. In the Bowling lawsuit, the plaintiff sought a preliminary injunction against the safety feature requirements of the Unsafe Handgun Act. These requirements include various safety features aimed at enhancing the safety of handguns. The plaintiff's goal was to challenge the legality of these requirements, asserting that they impose undue burdens on lawful gun owners. Both Bowling versus Bonta and Renna versus Bonta were heard before a 3-judge panel of the Ninth Circuit Court of Appeals. These cases have raised key points regarding the Second Amendment rights of Californian citizens and the scope of the state's authority to regulate firearm sales. The recent preliminary injunction granted in the Bowling case suggests that there may be legal considerations supporting challenges against California's handgun safety feature requirements. The outcome of these cases could have significant implications for the right of California gun owners and the extent to which states can impose such safety requirements on firearm sales. While this overview provides a general understanding of the ongoing legal proceedings, it is essential to await the final rulings and decisions of the Ninth Circuit Court of Appeals in Bowling versus Bonta and Renna versus Bonta to gain a comprehensive understanding of their impact on California's handgun regulations. Legal developments in California's handgun requirements. In the ongoing legal battle surrounding California's handgun safety requirements, significant developments have unfolded, shedding light on the status of various safety features mandated by the state. Here, we delve into recent events and their implications. Following a decision from the United States Circuit, California obtained a stay specifically concerning the impact of the ruling on chamber indicators and mag disconnects. Interestingly, The state seemingly conceded the infeasibility of the microstamping requirement, a concession likely driven by the widespread understanding that microstamping lacks practical viability. Despite this, numerous handguns have entered the state's roster, provided they include mag disconnects or loaded chamber indicators. Notably, an injunction on the microstamping requirement remains in effect. Subsequent to the Bowling decision, another favorable outcome emerged from Judge Dana Sabraw in the Southern District of California. This ruling pertained to the FBC Rena case. Both cases have been presented before the U.S. Circuit in a 3-judge panel format. Anticipating challenges to these decisions, the cases were, in a sense, consolidated and heard by a trio of judges in the Ninth Circuit.
This rule turns law-abiding gun owners into felons is a result of unelected bureaucrats.
Implementation of Oregon's new landmark gun control measure, a federal judge could delay the permit requirement.
Initial expectations regarding the composition of the panel were inclined towards a 2-to-1 lean favoring the state of California. This projection was rooted in the composition of the panel, consisting of judges Berzin, Rowlandson, and Bress. Given the political leanings of Berzin and Rowlandson, who are typically associated with more liberal perspectives, the odds seemed in favor of California. Recently, oral arguments were presented before the panel. The session went relatively well, considering the potential challenge posed by the panel's leanings. Notably, Judge Berzin, often associated with a more left-leaning stance and having previously ruled against Second Amendment cases, exhibited some resistance to California's stance. Specifically, she raised concerns about the viability of microstamping technology and questioned the state's lack of evidence supporting its practicality. Based on the oral arguments, the temperature of the panel seemed to lean towards upholding the lower court's decision to strike down the microstamping requirement. There is a possibility that other requirements, such as the loaded chamber indicator and mag disconnect, may remain in place. However, the situation remains fluid, and the ultimate verdict is yet to be determined. These ongoing developments mark a significant juncture in the legal trajectory of California's handgun requirements. As the courts deliberate on these matters, the implications for Second Amendment rights and firearm regulations in the state remain pivotal. It is essential to continue monitoring these cases to gain a comprehensive understanding of their outcomes and the broader impact on California's firearm regulations. Complex legal considerations and panel dynamics. The recent oral arguments held before the panel shed light on intricate legal nuances and panel dynamics, offering insights into the potential outcomes of these cases. Notably, discussions centered around whether the lower courts were justified in issuing a mandatory injunction, which prompted a technical exploration of the case's premise. It's evident that at least one judge may be attempting to find an exit from the case based on this technicality. Even Judge Berzin, often aligned with a more liberal perspective, challenged California's argument that the injunction compelled the state to undertake specific actions, such as testing particular handguns. Interplay of Bruin framework and panel's approach. It's critical to note that the analysis is expected to adhere to the Bruin framework, which involves examining the text of the Second Amendment and relevant historical context. Under this framework, any restriction impacting the right to own a handgun must be justified through historical precedents dating back to 1791. In the end, the outcome of these cases will be shaped by these complex legal considerations, the interplay of panel members' perspectives, and their alignment with established legal standards or divergent approaches. As these deliberations unfold, the fate of California's handgun requirements and the broader implications for Second Amendment rights remain at the forefront of legal discourse. Staying attentive to the panel's eventual decisions will provide a more comprehensive understanding of the legal landscape. Notable advocacy by pro se lawyer Aaron Murphy. It's worth highlighting the commendable performance of pro se lawyer Aaron Murphy, a dedicated advocate for Second Amendment cases in California. Murphy adeptly countered the arguments put forth by Judge Berzin during the Ninth Circuit's proceedings. Murphy's proficiency in navigating Second Amendment laws and his deep understanding of firearms contributed to his effective defense, adding a valuable layer to the arguments.
Could lose the ability to use these tools and as a result may not be able to operate their firearm.
Both Oregon's Attorney General and the Department of Justice asked the state Supreme Court to overturn that ruling.
Under the new rule, these firearm owners will be required to obtain special registration.
Congress passes most significant gun reform bill in decades, sends it to Biden. CNBC Stories.
The performance during these proceedings left an optimistic impression, given the challenges posed by the panel's leanings. Anticipating future steps and outcomes. While the belief remains that the state of California will secure a 2-to-1 victory, the fate of microstamping appears uncertain. The indications suggest that microstamping may not withstand the scrutiny of this decision, implying that this requirement could face potential challenges. It's envisioned that this case will eventually progress to the Ninth Circuit's Bond panel, and ultimately the Supreme Court. These higher levels of review will provide a clearer understanding of the implications of these arguments and the potential outcomes for California's handgun roster. Pending the ruling, these initial impressions underscore the complex and dynamic nature of the legal process. While there are expectations about the potential outcomes, the final decisions will be made after thorough deliberation and assessment of the presented arguments. That's all for this video, folks. We'll see you next time.